Investments. I'd like to reserve 5 minutes for rebuttal.
Fine.
Quote, "There can be no exercise of the right of eminent domain under the Constitution unless property taken is to be appropriated to the use of the public," unquote. Those are the words of the Tennessee Supreme Court in 1907. Notice that there are no exceptions made for partially unconstitutional takings or only small unconstitutional takings. There's no exception for takings that are to be used for a private purpose if the government can theorize a benefit being conferred. None of the excuses offered by the city in this case are given any weight under this holding. Instead, for over 117 years, it has been unconstitutional for the government to take anyone's property rights, yours, mine, Mr. Bibbs, RLR's, to benefit private property, period. The government can only take property rights, all property rights, for a public use. And when there's any question about whether the government has exercised its eminent domain power correctly, the courts of this state hold the government to an exacting standard. Quote, "Tennessee courts have long held that the power of eminent domain is against the common right, and all grants of such power are to be construed strictly against the condemnor and liberally in favor of the rights of property," unquote. There's no real dispute in this case that the city of Pigeon Forge took RLR's property rights in the duplex property for a private use. What we are watching in real time is the city running from these facts, trying to dress them up really hard, to obfuscate them enough that so the city can get away with that.
So, Mr. White, I don't see anything in the order of possession that specifically says that property is being taken for parking spaces. Is that a problem?
In the diagram to the order of possession, there's a specific drawing in which that was appended to the order of possession. There's a specific drawing that says this is the construction easement on the duplex property is for the creation of parking spaces. And the parking spaces are actually on the design, the diagram, to the appendix of the order of possession. Everybody acknowledges before the trial court that the city, this is a matter of judicial admission. The city has already admitted that the purpose of taking the construction easement on the duplex property, there was only one purpose, and that was to go into the duplex property to create these parking spaces. That was the only purpose for it. And the order of possession, the only reason that was included in the order of possession was for that specific purpose. Everybody acknowledges that there was no reason to get a construction easement on the duplex property for the Greenway project. It wasn't needed. It wasn't necessary.
Okay, but ultimately, you all communicated to Pigeon Forge that you didn't want the parking spaces, correct?
Correct.
And they weren't provided.
That's correct.
So that was a temporary easement? Is the easement still there for the parking spaces?
The easement was a matter of record for years.
But it's not there anymore? That's
a question of debate. The trial court kind of said the easement's no longer good, but it never was removed from the Sevier County record of deeds. It was still there for years and years and years. Let me dispel the concept that this is somehow a temporary easement. First, when a property owner has a bundle of rights, 100% of the bundle of rights, one of those rights is the power to go into that property and to change its fundamental nature. The city of Pigeon Forge took a construction easement from RLR, meaning it took from those bundle of rights and said now the city of Pigeon Forge has the right to enter RLR's property and fundamentally change the nature of it.
Let me tell you what it seems to me. It seems to me like, and you correct me if I'm wrong, but it seems to me like when all this was happening, and this is me sort of editorializing based on what I'm looking at in the record, it seems to me like when the city first came and said, hey, we need to take this property for the Greenway, RLR wasn't super happy about that. And as part of the perhaps discussion about that, it was negotiated that, well, you're taking away our parking spaces and we need our parking spaces. And it was agreed that the city would provide parking spaces, but it sort of seems to me that that sort of goes to maybe compensation for the taking, not whether they could take it. But then ultimately, I think RLR concluded, well, I think we have a better argument to say, hey, you're taking this for parking spaces, which is private, so we don't want them anymore, so now we're going to attack the entire taking. Correct me if I'm wrong.
Your Honor, respectfully, there is no evidence of that in the record.
Okay.
The only evidence in the record is and I respectfully submit that that you're drawing assumptions and conclusions from facts that do not suggest that. The only evidence in the record is that RLR objected to this taking multiple times. We objected to the order of possession that included the construction easement. We filed multiple motions after that saying that this was an unconstitutional taking. The sole testimony, the only testimony in the record, is that RLR's from Mark Sherman, their director of property, saying we didn't want parking on the duplex property. And Your Honor, why would RLR want parking on the duplex property? In the end, this was a scheme by the city to artificially reduce its exposure and damages to RLR. Why? Because the city knew it was taking 6 parking spaces from the hotel property, forever damaging the hotel property. So what did they do? Instead of wanting to pay for RLR for that damage, and keep in mind, the city was pressuring property owners to donate their property. They pressured RLR to donate their property. When we refused, they said, how do we get this property for the cheapest price? So what they did was they hatched this scheme. Instead of paying RLR for the full damage to the hotel property, they said, hey, let's take 6 parking spaces from the duplex property and create it there, so now we can argue that they're even Steven, because they have 6 parking spaces on the duplex property. But the answer there is that means the city forever subjugated the duplex property to the hotel property. The only way that works is if forever in time, the duplex property, a portion of it taken by the city, must now serve the hotel property. Why in the world would RLR ask for that? That has never been, it's not in the record, it was never asked for. It was a scheme hatched by the city to try and reduce the amount of money they had to pay here.
Excuse me for interrupting, counsel. Did the trial court in any of its orders address what you've just articulated?
The trial court, indirectly, Your Honor. We've certainly made that argument to the trial court. The trial court simply felt that there was a public purpose for the taking. Really didn't give us much details as to how exactly the public purpose was here found, given that the construction easement was taken for one, and everybody, I mean, the city's lawyer on the record, judicial admission. I mean, last time I checked, when a lawyer makes a statement on behalf of a client on the record, that's a judicial admission. The city's lawyer said, quote, they're right, RLR's right. This was taken for a private purpose.
So, excuse me for interrupting again. When your client requested that the city not construct the 6 parking spaces on the duplex property, does that not establish some sort of estoppel that your client would have to confront?
Well, first of all, the concept of equitable estoppel, which I think Your Honor is referring to, because there has to be some grounding of the law with respect to estoppel. What is that? It has to be equitable estoppel. In a situation like this, there's no real basis for equitable estoppel. First of all, the record is replete with RLR saying, do not put the parking in place. We objected to the order of possession. The fact that we didn't want them to build the parking spaces does not affect the fact that the taking was unconstitutional from the start. So if the theory being, hey, if you unconstitutionally take my property for a private purpose, and I object saying, don't do it, the fact that I object means I've waived the ability to claim that that's an unconstitutional taking? That, I would respectfully suggest, dramatically shifts the power of eminent domain. That, to me, does not sound like strictly construing the power of eminent domain against the government and liberally in favor of property rights. If the city takes property rights, it must be for a proper purpose. And I would respectfully submit, Your Honor, what the property owner does after that taking is not relevant. The Constitution of this state does not say the city cannot take property for a private purpose, unless we can find some estoppel after the fact that gives us a way to backdate and say, you know what, maybe that's an okay idea. The Constitution says you can't do it. Private purpose, you can't do it. We have judicial admissions here on the record from the city that this was taken for a private purpose solely to benefit a private property owner RLR and not for the public purpose, the Greenway. Those facts establish unconstitutional taking.
Your time's up, but I do have a question. I want to make sure I understand the facts correctly, because you've been saying that RLR continued to say we don't want the parking, but there's some notes in here in the facts where the director of properties testified that they were interested in the city finding a way to replace our parking and possibly even bring more parking. That would have been a big bonus for our property. And then Mr. Sherman later said, I wanted replacement parking. When it was first brought to my attention, it was like, I need my 6 spaces and more. So at some point, they did want the parking, right?
Your Honor, I would ask you to read the entire, we quoted it in our brief, the entirety of Mr. Sherman's testimony, and we put it in our brief, is clear, where he says, we didn't want parking on the duplex property. We didn't want any of this taking. And I will again say, Your Honor, an unconstitutional, how do you cure? Is the decision that this court is going to pen, that the property owners are going to look to, is that the state can take property unconstitutionally for private benefit, and we'll let it happen if the property owner says something after the unconstitutional taking that allows us to go back in time and say, it's okay. Is that going to be the rule? Thank you, Your Honor.
Well, I have a question. Help me understand here a little bit here. When the jury awarded the monetary damages $276,000 some odd dollars.
Correct, Your Honor.
Did that include, was that based upon the fact that the 6 parking places they lost were going to be replaced by 6 parking places?
No. In fact, we specifically addressed that issue at the trial court. The issue of the parking on the duplex property was not brought up to the jury at all. At all.
So they placed a value on it.
Correct.
With an understanding that 6 parking spaces were going to be lost.
Correct.
Okay. Thank you. You have your time for rebuttal.
Thank you, Your Honors.
Hear from the appellee.
May it please the court, Brian Bibb of the Knoxville Bar on behalf of the city of Pigeon Forge. I think the court can pick up on the fact this case has been around a long time. There are a lot of legal issues and a lot of procedural issues. I'm going to try and cover just a few topics, but I'm happy to be redirected at the court's discretion to what it would like to hear from me on. I do think it's important to give just a little bit of context to some of the arguments that have been presented. Among them, I think, is an understanding, which I think the court may have, of the procedural structure of a condemnation action. It's bifurcated. Of course, the first step is a decision on possession. That was actually made quite a long time ago. The hearing on possession was on April 21st of 2016. Order of possession was entered on May 31st of 2016. I think it's important to note that not present in the record is any transcript of that hearing at which evidence was presented and witnesses were examined. No statement of the evidence has been presented under Rule 24, which to some degree hinders the court's ability to review the original possessory decision, which is important because actions are taken in reliance upon that possessory decision. Title transfers after that possessory decision. Construction begins. The Greenway was built in early 2018 and has been in operation for 7 years.
Mr. Bibb, let me ask you this. The order, of course, itself doesn't speak to specifics, but there was attached to the order a plan, for lack of a better word, that did show 6 spaces being used for parking. And do you agree that that would be a taking for a private purpose, not a public purpose?
Let me address that directly. Okay, so the temporary construction easement, I think it's important to correct one thing that was said by my opposing counsel. It is not true that the temporary construction easement on the duplex track was solely for the purpose of building the parking. A temporary construction easement was necessary for access and working room for greenway construction. There were four easements acquired, 2 permanent greenway easements, which are for forever to maintain the walking path, and 2 temporary construction easements. The temporary construction easements were terminated by order of the court, which has not been appealed, on September 4th of 2018. So those easements are done, okay? They've been terminated. Those were terminated on September 4th, 2018, and were ordered for access and working room to stage materials and construct the greenway. They were terminated upon conclusion of construction no later than September 4th of 2018. A temporary construction easement was necessary on both tracks. The temporary construction easement is the only easement in dispute. Plaintiffs concede that there was a public purpose for both greenway easements and the temporary construction easement on the motel tract. The defendant, I got the parties wrong, I apologize. The defendant only maintains that there is some infirmity for the temporary construction easement on the duplex tract, but it was supported by a public purpose. Our position, and it's consistent with the statute, 2917, make sure I get it right for the court, 102D specifically permits incidental private use or incidental private benefit. It's a statutory creature. Condemnation is governed by statute. So in other words, it is not the standard for eminent domain to view it in microcosm. Okay, let's look at this pole. Let's look at this thing. Is every aspect of it truly for a public purpose, or does it serve and that's what Ms. Wyrick said, the statement that they've relied on for years, that Ms. Wyrick, who was City of Pigeon Forge attorney at the time, what she said, which is entirely consistent with the arguments that we've made, is the public purpose is not the parking, the public purpose is the public purpose of the project. It is in furtherance of the overall project. So let me then go back to your specific question, okay? First of all, the construction drawing which is attached is dated 2012. So it is a construction drawing 4 years from before the order of possession. We've cited authority for the proposition that a construction drawing does not bind or specifically set in other words, it doesn't constitute an abandonment or an...
Are you saying, I mean, was there any real dispute that the original taking on the duplex property by the city was to construct 6 parking spaces?
No, I mean, that was part of the construction. There was no permanent taking.
I understand, but that was part of the whole deal, as you put it.
That was part of the overall project.
Overall project was to take, let me finish,
yes,
it'll work better. To take that part of property on the duplex property, even though it's owned by the same entity, and construct 6 parking places to replace the 6 the hotel lost.
That was correct. Based upon the requests that was made, that was part of the original plan.
And then later the city abandoned, for whatever reason, the constructing of the 6 parking places on the duplex property.
I quibble with the use of the word abandoned,
what would
but
you
the city
say?
Didn't build them. The parking spaces were not built.
The city didn't build them?
Correct. They asked us not to build them, and
Okay.
we didn't build them. And I think it's also important to note that this was not an acquisition of any permanent interest. All the city had permission to do under the temporary construction easement was to bring their equipment onto the property and lay asphalt. It was a temporary transfer. There was no...
Lay asphalt's kind of, you kind of brush through that part quickly. They didn't
That's true.
It wasn't
That's
just
true.
to bring their construction.
That's true. But they were
it wasn't just to bring the construction equipment on the property. It was to bring it on the property and lay asphalt.
That's true. At which point, the property owner would be perfectly free to do whatever they wished with that
And
asphalt.
tear the asphalt up.
Sure. It was not, the city was not acquiring that interest. And it was, again, our position is that, number one, it was served the public purpose of the overall project. Number two.
How?
Because it's like Greens.
No, don't get frustrated.
No, I'm not.
Just tell me. I mean,
Absolutely
I understand.
not.
I am no expert in this. I will readily admit that. So I'm just trying to understand what was the public purpose for constructing or planning to construct or proposing to construct 6 parking places on the duplex property.
Because it was in furtherance of the overall public purpose.
And
let me
how?
give you some. So similar to, for example, when TDOT lays a road and reroutes a driveway. That is part of the process. When TDOT installs walls or green space buffers adjacent to a highway, Those are in furtherance of the overall project. Are they necessary to construct the road? No. Do they have an incidental private benefit to the landowner who is benefited by that wall or green space buffer, or the relocation of a driveway, or the regrading of property, or the relocation of a sewer line? Yes. All of those things have incidental private benefits. This had an incidental private benefit to RLR, but it was part of an overall acquisition that was undoubtedly supported by a public purpose. And let me also add, it was never constructed. So even if it was an aspect of the original order of possession, at the moment that RLR decided that we no longer want this built, the city said, all right, well, if you don't want it built, we won't build it. And let me add that when there was a dispute over the city's obligations under the order of possession, the city went to the circuit court, asked for the circuit court's opinion and guidance on what the city's requirement was. The circuit court opined that the order of possession did not require the construction of any parking spaces. And the circuit court concluded that the temporary construction easement had terminated. So to the extent there was any dispute over whether the city was required to make this construction, the city went to the circuit court, obtained the court's guidance. Again, that order providing guidance to the parties is not subject to appeal. All that is subject to appeal is the public purpose determination.
Counsel, excuse me for interrupting.
Sure.
As you know, one of the issues is whether there was an abandonment by the city. Could you address that, please?
So abandonment is statutory. So under the current statutory scheme, under 2917-912B, the defendant must show that the proceeding has been abandoned by the acquiring party. The proceeding has been abandoned. The defendant cites to Shelby County versus Cruz and Anderson versus Smith, which are two appellate decisions, one from this court and one from the Supreme Court, which stand for the proposition that an entity cannot non-suit a condemnation proceeding after obtaining possession. And there are several cases to that effect. It's not what's happened here. The city saw this proceeding through to its conclusion, tried this matter before a jury. The jury awarded just compensation. And so there has been no abandonment of the proceedings. When that issue came up, the question of whether the city was legally required to build those parking spaces, again, the city brought that issue before the circuit court, and the circuit court made a determination, interpreted its order, gave guidance to the city on what it was or was not required to do, and the city acted in reliance on that order, which again has not been appealed. So from an abandonment standpoint, the city has taken the position that they were not required under the strict terms of the order to actually build the parking spaces. The city completed the project, and that to constitute an abandonment, there must be a showing under 2917-912 that the proceedings themselves have been abandoned, which is not the case. And as I think came up during questioning, there was a meeting on the property in December of 2017, at which point RLR's representatives asked the city not to build the parking. And so the city didn't build the parking because they had been asked not to do it. The entire purpose of that parking was to, provide some sort of accommodation to RLR as part of the overall Greenway construction process. So our position is that there has been no abandonment of the proceedings, and 2917-912 constitutes a waiver of sovereign immunity because it results in an attorney fee award, so it should be strictly construed. Let me discuss briefly some of the decisions that I think it's important to understand what's being appealed. I think there are two things that have been appealed. The first is the order of possession, which was entered on May 31st, 2016. Again, as we've explained in our brief, the absence of a record of that hearing is certainly a hindrance. In fact, we can't even conclude from the hearing that the issue of the propriety of this parking was even raised before Judge Vance at that point. We simply don't have enough information to reach that conclusion. Instead, what we have is a series of what are essentially motions to reconsider that decision. There were one motion to enforce and two motions for summary judgment. And the order that has been appealed from is the second motion for summary judgment, which was entered in July of 2022. The position that we've taken is that that judgment should be reviewed for abuse of discretion rather than de novo. To the extent that it's been styled as a motion for summary judgment, it was a motion to reconsider the order of the court at the evidentiary hearing. And so our position is that should be reviewed for abuse of discretion. The court, I think, is aware this matter was tried from November 13th through the 16th. The jury awarded $276,931.62 plus prejudgment interest. They were fully compensated for these lost parking spaces. They were fully compensated for the temporary construction easement at issue. That temporary construction easement was calculated based upon the square footage that was acquired and how long it was held, and they received compensation for that temporary construction easement based upon the time that it was held for. So there has been full compensation. This matter is proceeded in the ordinary course as it ought to have. Let me go back briefly to address public use. I think I've dealt with that a good amount in dealing with the court's questioning. I think it's important to note here that the disputed replacement parking our position was never actually ordered to be built. It was never built, and it was part of only a temporary construction easement that was terminated by entry of the court's order on September 4th of 2018. I think in response to Judge Swinney's question, we've cited a number of cases dealing with incidental private use. Those are in our brief. I'd encourage the court to read those. But the point that I think probably inartfully I was attempting to make in response to Judge Swinney's question was that it is not unusual or atypical for there to be attempts made to accommodate a landowner as part of a public work project. That's what this was. And there are other circumstances in cases we've cited where that has been found to be permissible. And let me also say that there is no proof in the record of any sort of nefarious or diabolical scheme hatched by the city of Pigeon Forge to try and avoid paying money. This is part of normal municipal operating business. Ultimately, this matter was tried and they received the compensation to which the jury found that they were entitled. I'm happy to address any other questions the court has. I know this is a complex case. I'd refer the court to the extensive briefing, and I know there's a large record over there for the court to read through. Thank you for your time.
Thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honor. First, on the question of private taking with no public purpose, I think the record is replete with evidence on that, including many admissions by the city. For example, in July 2018, the city admitted in its written response to RLR's motion that, quote, on plaintiff's plans, it had proposed constructing parking spaces on the adjoining tract owned by RLR to provide replacement parking solely for the convenience and benefit of defendant RLR, unquote. Those are the city's words. There's no dispute. And the city manager admitted that, doubled down under oath, and said there is absolutely no reason for us to get that, to build that replacement parking other than to benefit RLR. It had no benefit to the Greenway. Next, Mr. Bibbs suggested the fact that they were never constructed is somehow meaningful here. It is not. The simple fact is the city took from RLR the right to enter our property through the construction easement on the duplex property to build these replacement parking spaces. That was one of our property rights. It's gone. It was gone for a period of time. That is whether or not you actually go in and construct the parking is not relevant to the fact that you took our property rights to go, in fact, do that. We had less than 100% property rights while they took that easement for that purpose, and therefore there has been harm whether or not the parking spaces were actually constructed. The question of abandonment. You know, and Mr. Bibb talked about Anderson and Shelby. Anderson and Shelby stand for the proposition that once the government cannot voluntarily alter the scope of a condemnation after obtaining an order of possession. In those cases, the government used a voluntary dismissal to alter the scope of the order of possession. Here, it's the city's intended announced renunciation of the right to go in and construct parking spaces. There's no difference between Anderson and Shelby and this case because the government relinquished a property right it took from a citizen through an order of possession. The fact that Anderson and Shelby had occurred through a voluntary dismissal, and here they just said, we're not going to do it. In the end, it's the same thing. That's a distinction without a difference. Same principle Anderson and Shelby applies here. On the suggestion by Mr. Bibb that the construction easement was somehow only necessary for constructing the Greenway on the duplex property, I ask your honors to look at the construction easement on the hotel property. It's 1,786 square feet. But the construction easement on the duplex property is 5,210 square feet. And the plat attached to the order of possession shows new construction area. The difference between those two recognizes that the construction easement on the duplex property, it was there so they could build the private replacement parking, just like the order of possession suggested. Finally, the city wants you to believe that this is a unique case, one solely about RLR and its two pieces of property in Pigeon Forge. But this case is much larger than that. It's about all of the property owners in Tennessee facing the awesome power of the government to take their private property rights. The vast majority of these citizens, your citizens, do not have the resources to litigate against the government for years, to try the issue of compensation to a jury for a week, before they can be heard before your honors on the city's unconstitutional taking. For them, your honors decision here is all that they will have. Your decision will either protect them or leave them to the mercy of the government. This court stands as the guardian at the gate for the citizens who would otherwise be at the whim of the government's insatiable desire to grow itself and its benefactors. If your honors don't protect the citizens' rights in the circumstances, then who will? If you pen the decision that the city is asking of you, what will be next under this court's authority? When the government uses this court's decision as requested by the city to dictate to another private property owner what benefit they must enjoy on their property, or takes their private property to benefit the private property of another, will that be the justice that this court stands for? That your honors took your oath to be here in this great position. This court has the opportunity now to stand for those property owners. We ask you to do that, to hold firm to their belief that this court stands above all else for them in the face of an unconstitutional taking. We ask your honors respectfully to strike down this unconstitutional taking.
Let me ask you, help me here some more. Exactly what relief are you asking from this, requesting from this court?
A determination that the taking was unconstitutional for two reasons. One,
the taking as to the hotel, excuse me, as to the duplex property.
that this was one order of possession. This is one order of possession. The city elected to go to the court and say, in one order of possession, we want to do all of this. If the order of possession is unconstitutional because it includes a private taking, then the order of possession is unconstitutional. There is no court in the history of this state, and we have looked in the history of American jurisprudence, that has said, you can kind of parse it. If there's some unconstitutional parts and there's some constitutional parts, you can kind of split it and pick it and choose. No. If an order of possession, as the city crafted it, includes an unconstitutional taking, strictly construing the right of eminent domain against the city and liberally construing it against property rights, I respectfully submit, calls out and requires us to say that order is unconstitutional. It should be struck down, and the matter should be sent back to the trial court for a determination of attorney's fees for RLR because the order of possession is unconstitutional. The other thing I think the court should consider is a finding that there was an abandonment, that the city clearly took the right to enter RLR's property to construct private replacement parking and did not do so, and said so on the record, hey, we're not going to do that. There's no difference between voluntarily dismissing your request for private replacement parking rights and saying we're not going to do it. In the end, it's the same thing. So that's the second aspect of the order that we would ask this court to issue.
Thank you.
Thank you, Your Honors.
Thanks to counsel for both sides. We appreciate your briefs and your arguments on this. If you would, adjourn court till our next docket in February.
All rise. This honorable